Lords, before I develop my submissions on ground one, there's just a couple of housekeeping matters. Board has this morning, probably only in the last 15 or 20 minutes, been sent a transcript of evidence given by Miss Shaw in a Bermudan criminal trial from March 2015, which is the Queen and Levesque Roberts. The board might have seen reference to that. It's referred to in Miss Shaw's second report at footnote 2, which is page 3417.
I'm just checking we've received the transcript.
I think there was some issues about the size of the file, and so the board might have only received what's referred to as part 1 of that transcript.
I expect I'm behind with the technology, Mr. Poole, but I'm not sure I have seen that.
My Lord,
We've got quite a lot of other evidence from other trials.
my Lord, you have, and this is a...
I'm just looking on the shadow.
It's coming now. Yes.
My Lord, I don't propose immediately to take your lordships to it, and when I do, it will only be a short point when dealing with the fresh evidence.
Thank you.
And it's related to the Bermudan survey, because there was some examination in chief of Miss Shaw at this criminal trial in 2015 about the surveys she'd carried out previously, and there was some cross-examination that I just wish to draw the board's attention.
And what's the name of the case?
It's Levesque, L-E-V-E-C-K, Roberts.
Thank you.
And the second bit of housekeeping...
Forgive me, will we send this morning?
My Lord, yes, and only probably about 15 minutes ago, I think.
More like 15 seconds, actually.
I think attempts were made earlier.
An additional authority.
I think
my Lord, can I assist?
the additional authority, I think, relates to the Court of Appeal decision in the criminal trial, Levesque Roberts.
When we had noticed that the respondent was
We've got it.
to put in the transcript, we thought it was right that you should have the views of the Court of Appeal on what transpired at the trial.
Yeah.
Oh, I see. So this is the Court of Appeal.
This is what we've got so far.
Yes. Well, I've got one that starts President on 6th April 2015. Sounds right.
That's the document we've sent in, and I was told that the respondents had...
That may not be the one you're referring to.
My Lord, it sounds as though that's the Court of Appeal, Judge.
Yeah, it is.
And perhaps when I then get to the point on the fresh evidence that I need your lordships to see the transcript, I can then ask your lordships to see whether it's come through at that stage. And if not, we may need to then take steps to provide you with a hard copy. But as I say, the point is very short, and I can make my submissions even necessarily without reference to the transcript. The second bit of housekeeping is, I think, something else that's been sent through this time by the appellant is what's described as a schedule of GSR findings.
Yes, and that was in response to our request.
Yeah, well, yes and no, my Lord. And the reason I say yes and no is I think, as I understood the board's request, is you had a schedule of GSR findings in respect of Mr Hewey that was annexed to the appellant's case. And I have had a chance to review that when I got the appellant's case, and I'm satisfied that that's accurate. And the reason I say that is it includes, for example, the black shirt that we had some submissions about yesterday. This new schedule does include the particles relating to Mr Dill as well, which start on page 4, internal page 4 of the schedule. But then they include in those particles the black shirt, which I say is wrong. So if this... I think the short point is I'm quite content for the board to have regard to the schedule annexed to the respondents to the appellant's case in respect of Hewey particles. I think if we're going to present an agreed Dill particle schedule, I'll need to have some time to look at that.
So the black shirt's on both at the moment, is it?
No, it's not. Black shirt is in appellant's schedule allocated to Hewey. It's now in the new schedule allocated to Dill. Right. And I say, for the reasons I said yesterday, that's wrong. Sorry? What, in the schedule that's been sent through? Yes. Oh, so the schedule's different from that. Right.
Well, Mr Poole, I'm sure you'll have time after the hearing's over, but please do it this week to see whether this schedule can be agreed. And if you want to say there's something wrong with it, you can let us have that in note form. And the parties have done very well in agreeing matters up to now, and I can't believe that this will cause anything other than a very short-term problem.
No, my Lord. So those two housekeeping matters, then on with ground one. And The first point is why we said there's no basis for challenging the decision of the trial judge, and then I'll secondly move on to consider Ms Shaw's fresh evidence. The board was taken yesterday by my learned friend to the defence objection to Ms Murtha's evidence. And the defence objection was, in essence, that the reports that she had submitted to date were not sufficiently clear as to what she was saying about the 1 and 2 component particles, and that in those circumstances it would be unfair to admit the evidence. And the board sees that from 841 lines 7 to 22. And the judge saw some force in that argument and, as a result, gave permission, rather, for the prosecution to serve a further report from Miss Murtha, which prompted the February 2013 report. But the judge made it clear in my submission that the defence could renew any objection once they had considered that further report. And you see that at 842 lines 20 to 23, where the judge stated that the defence objection was not a sufficient reason to exclude the evidence at this time. And then the judge went on at lines 13 to 14 to direct the prosecution to serve a further and better particulars effectively. And he said, lest I may revisit this issue and make a further ruling. And as I say, that then prompted the February 13 report. That's the report where Miss Murtha, as the board's seen, explains the significance of 1 component and 2 component particles when found with GSR particles. That, as the board saw yesterday, is entirely consistent with the ASTM and the SWAG GSR guides. It was also consistent, as it turned out, with Mr White's evidence that he then gave at trial. And unsurprisingly, in the circumstances, neither Mr Dill nor the appellant made any further objections to Miss Murtha's evidence. So in my submission, the judge can't properly be criticised for admitting the evidence. Then one looks to the Court of Appeal's consideration of the admissibility issue, and I took the board yesterday to paragraphs 36 and 37 of the Court of Appeal judgment, which is page 501. And as we say in our written case, we say that the Court of Appeal was plainly justified in dismissing the admissibility arguments for the reasons they gave at those 2 paragraphs, 36 and 37. I won't take the board to them again, as I highlighted them yesterday. If I can turn then briefly to an authority on the admissibility of GSR, and I say briefly because, again, the board has this in writing in our written case, and my learned friend referred you to it. It's the case of Dwayne George. And we address this at paragraph 32 of our written case, which is 3536. And we do say that a parallel can be drawn between the present case and the Dwayne George case. The board has Dwayne George at 3662. And as the board will have picked up from submissions by my learned friend yesterday, that Mr George's case was referred back to the Court of Appeal by the Criminal Cases Review Commission following the submission of fresh evidence in the form of a report by Ms Shaw. Now, the evidence against the appellant in that case, you can see summarised at paragraph 8 of the Court of Appeal's judgment, which is 3665. Part of the circumstantial case was particle evidence, and we see at paragraph 19, which is 3667, that there were 2 3-component particles and 2 2-component particles. And then you see at paragraph 34, which is 3670, a summary of Ms Shaw's fresh evidence. And then the Court of Appeal at paragraphs 42 and 43 consider and quote from the well-known case of Barry George and the case of the Queen and Joseph. And then they conclude at paragraph 46, there's no basis to challenge the admissibility of the particle evidence in the case, and neither did Ms Shaw's new evidence justify such a view. And we submit what is said at paragraph 46 by the Court of Appeal can be applied with equal force to the present case. And then the Court of Appeal go on at paragraph 47 to make the point Lord Hughes made yesterday about the absence of evidence not being the same as evidence of absence. And we submit, again, that observation is equally pertinent to the present case, and explains why Miss Murtha's evidence that she gave regarding the 1 and 2 component particles found in the appellant was relevant and admissible as part of the prosecution case against the appellant. Now, before considering the impact of the fresh evidence in our case, Just want to address some complaints that are made that don't necessarily rely on the fresh evidence by the appellant, and they fall really under three headings. First, they say the particle evidence is inconclusive evidence and therefore of no probative value. Second, they say the admission of the particle evidence caused irremediable prejudice. And third, they say that the Court of Appeal, as well as the trial judge, misunderstood the particle evidence. Now, we do address these in writing at paragraphs 35 to 39 of our case, which starts at 3537. If I can just highlight some of our submissions in response. So dealing first with the inconclusive evidence point. We submit it is plainly wrong to say that simply because evidence is inconclusive, it has no probative value. As we all know, a piece of evidence may be of no consequence when viewed in isolation, but can acquire probative value and relevance when considered in the context of other evidence. And so, for example, in this case, the three component particles found on Mr Dill was evidence that the jury were entitled, in my submission, to consider when assessing the potential relevance of particles found on the appellant. And that's because, as we submitted yesterday, the presence of the three component particles on Mr Dill's possessions is evidence supporting an inference that the appellant was with Mr Dill when he shot Mr Robinson, given the way that the defence case was put, or rather the lack of challenge from the appellant to Mr Dill's account that he was with the appellant all night. Now, the appellant submits that inference, they say, is unsustainable, given that ordinary members of the public can acquire particles when going about their day-to-day activities. Well, as to this, and I'll come back to this when looking at the fresh evidence, but as to this at trial, in my submission, the jury were well aware of the significant risk of environmental contamination. It was a central plank of Mr Dill's defence, and it was accepted by both experts. And I think the board were given the references yesterday to Miss Murtha's evidence, where she accepted the particle evidence could have originated from a variety of sources, including naturally occurring dust. And the references are 2142, line 3, 2142, lines 15, over to 2143, line 19, and then again at 2144. And that was also Mr White's evidence, and the reference to that is 2927, 12 to 20. And that was, in my submission, appropriately summed up by the judge. And you see that at pages 210, 214, and 219.
10, 214.
210, 214, and 219.
Yep.
The jury, in my submission, therefore, were more than able to assimilate evidence as to potential significance or lack of significance, because there was an appropriate explanation of that potential significance. For example, here, what might occur naturally in the environment or might otherwise be a consequence of innocent contamination. And as I say, I'll return to that point when looking at the fresh evidence in a moment, but that's inconclusive evidence complaint. The next is prejudicial effect of admitting the evidence. And the appellants developed this at paragraph 6.8 to 6.9 of their case, and they effectively say the jury were led to believe that there was a particular or special connection between one and two component particles, or that one or two component particles were a type of gunshot residue, is what they say. And we respond to that in our case at paragraphs 37 to 38. And the overarching point is the one I made yesterday, which is neither Miss Murtha nor prosecuting counsel nor the judge suggested at any stage that it was possible to deduce from the presence of the particles found on the appellant's person and his possessions whether or not they came from a discharge of a firearm. And in my submission, the jury would have had well in mind that it was equally as likely that the one and two component particles originated from the discharge of a firearm as from an innocent source. And I gave the board the references yesterday to that. In our case, Miss Murtha's evidence, the references are set out at paragraph 20, as regards Mr White at paragraph 22 of our case, and then the judge's summing up at paragraph 24 of our case. Now, the appellants give four specific instances where they say that they rely on to make good their point about prejudice. The first is a point about terminology. And I submit there's simply nothing in this complaint Following the expert evidence, the jury would have well understood what was meant by 1, 2, and 3 component particles, and the fact that 3 component particles could be referred to as gunshot residue in the sense of a particle created as a result of a discharge of a firearm, potentially, as opposed to an umbrella term for all particles. And the judge made this very clear in my submission in his summing up. And the best example probably is page 233, lines 5 to 10, where the judge made it clear that GSR particles, i.e. particles that could said to have come from the discharge of a firearm, were 3 component particles. And the judge at one point referred to those 3 component particles as, quote, the real GSR. That's 227 at line 25. And the judge goes further and drew a distinction between GSR particles and 1 and 2 component particles, which he referred to as either GSR-related or GSR-like particles. That's 183 lines 13 to 14. So in my submission, the jury would not have been led into error by anything that the judge said in respect of how he used the term GSR. The second prejudice point is that the appellant say there was an overinflation of the particle evidence. And again, in my submission, that's simply not borne out by what Miss Merthyr said about the particle evidence and the care that she took to explain the limitations of the evidence. Having heard her evidence, I submit the jury would have been left in no doubt that the likelihood of 1 and 2 component particles found on the appellant and his possessions having come from a gun that killed the deceased was equally as remote as other possibilities and certainly on its own inconclusive. There's a specific complaint made about the statement Miss Merthyr gave that an average person would not be expected to have gunshot residue particles on them as well as 1 and 2 component particles. And that's the exchange that the board was referred to yesterday. It's 1992, line 19 to 1993, line 7. Now, in my submission, properly understood, Miss Merthyr's evidence is meaning that an average person would not be expected to have GSR particles on them as well as 1 and 2. It's a point that my Lord Hamblin made, and it's a point that we made in our written case at paragraph 38b at page 3538. And that is an entirely uncontroversial proposition that's not challenged by Ms. Shaw. And that's because it's universally recognised that the average person who is not exposed to firearms or ammunition or its components will not be found to have GSR on them. Even if her evidence is understood to mean that an average person would not be expected to have 1 and 2 component particles on them, that is not in any way misleading in my submission, as it's the presence of 2 component particles as well as 1 component particles that makes it less likely. And we see that from the FBI summary of the GSR symposium that the Lordships were taken to yesterday. It's the document that's annexed to the R.J. Lee supplemental report. And if I can just ask the board, it's I haven't got a page. It's the attachment, internal page 6 of 19, and it's a passage that Melinda Friend took the board to yesterday, where what is said is, it was widely agreed that the average person who is not exposed to firearms or ammunition or its components will not be found to have GSR particles on the hands. Michael Martinez conducted an occupational study of 102 random individuals from 74 different occupations. The individuals were residents from the community who had been called for jury duty. Only 1 person was found to have a 2-component particle on his hands. This juror reported that he had cleaned his hunting rifle 12 hours prior to being tested. These results indicate that the subject's daily environment can affect the likelihood of finding GSR. Now, in response to a point Melinda Friend made, it is clear when one reads that passage that GSR particles is being used as an umbrella term to mean 3, 2, and 1 component particles. It makes no sense otherwise. When you, particularly reading that last sentence, these results indicate subject's daily environment can affect the likelihood of finding GSR, when the sentence before is referring to 2 component particles. But for present purposes, the point I make here is that this is showing that only one person out of 102 random individuals was found to have 2 component particles on their hands. So there is nothing in my submission that would have turned in the jury's mind on the answer, the specific answer that's given by Miss Merthyr. And it was impressed upon them that 1 and 2 component particles could easily be the result of environmental contamination. So the short point is nothing turns on that. The third prejudice point taken by the appellant is they say Miss Merthyr effectively misled the jury into thinking the particles were likely to be GSR. Now, really, I've already addressed that point. What Miss Merthyr was saying in her evidence is that all reasonable steps were taken by her to exclude particles that definitely did not come from the discharge of a firearm because they had the wrong morphology or profile. As I said yesterday, she wasn't saying that having excluded those particles, what she was left with was more likely to have come from a firearm. And one of the examples my learned friend takes is page 202 of the summing up, line 7 to 203, line 8. And in my submission, all the judge is doing there is reminding the jury of Miss Merthyr's evidence that the correct morphology and lack of tags enabled her to say that a firearm was a possible source. This is not saying the absence of those contrary markers made it more likely that the particle came from an innocent source, and nowhere does she nor the judge say that. The fourth prejudice point said that there were critical omissions, it said, in Miss Merthyr's evidence. I can take this point shortly because of the submissions I made yesterday, because the first point is that the appellant is wrong in my submission to say that 1 component particles do not have evidentiary value unless accompanied by a GSR particle. That's the first point that is said that was a critical omission from Miss Merthyr's evidence. Well, I say that's wrong. That contention is impossible to sustain in light of the ASTM and SWAG GSR guides that we looked at yesterday. Secondly, I say the appellant's wrong to say that the 5 GSR particles found on Mr Dill's possessions were not relevant to assessing the probative relevance of the particles found on the appellant, and I made that point and addressed that yesterday. And thirdly, I say the appellant is wrong to suggest the jury would not have been left with the impression that 1 and 2 component particles could easily be the result of environmental contamination. The final point before moving on to the fresh evidence is what is said about the Court of Appeal's misunderstanding, and the suggestion being that the Court of Appeal, as well as the trial judge, simply just misunderstood the particle evidence. And I say for 2 reasons that submission is entirely without merit. The first point, the appellant notes that the Court of Appeal refer to varying kinds of GSR. Well, that is no more than using GSR as an umbrella term for 3, 2, and 1 component particles. And it would be wholly wrong in my submission to suggest that the Court of Appeal misunderstood the evidence and believed that 1 and 2 component particles were particles of GSR in the sense that they were particles that could be said to have originated from the discharge of a firearm. And we see the Court of Appeal clearly differentiating between different types of particles at paragraph 9 of their judgment, which is 490, and again at paragraphs 35 and 36, which is page 500. And the second point on the Court of Appeal, on the basis of the expert evidence and how it was presented and relied on by both prosecution and defence, in my submission, the Court of Appeal was entirely correct to consider the particles found on Mr Dill and the appellant as a population of particles, and I won't repeat the submissions I made as to that yesterday. So, in conclusion, both the judge and the Court of Appeal understood the particle evidence, and there's no basis for interfering with the Court of Appeal's assessment as to how the judge dealt with the particle evidence on this issue of admissibility. So I now turn to the fresh evidence.
Just before you leave the Court of Appeal, Mr. Poole, could you look at paragraph 9, please, page 490? I'm using it simply as an example rather than anything else.
My Lord.
You make the point that in this paragraph they clearly show that they've understood the difference between 1, 2 and 3 component particles, and we can see why you say that. look at the last sentence. Although no three-component particles were found on his clothing, the three elements of lead, barium, and antimony were all present. Now, at some point, could you address the submission which I think is made against you, that the judge and perhaps the Court of Appeal fell into error in thinking that the presence of, amongst a combination of one component particle of all three metals has some significance for their likely origin?
My Lord, yes, and I think the starting point is probably to look at what Miss Merthyr said about this at trial, and she addresses this at 1982, lines 9 to 22.
1982?
1982, lines 9 to 22.
Thank you. Sorry to be slow, Mr. Poole.
And what she explains there is that the number, in my submission, what she's explaining there is that the number and variety of particles is relevant when assessing the probability that a population of particles is GSR. Yeah. Now, she's made the point, and it's a point I made yesterday, that when dealing with GSR, i.e. three-component particles, whether you have one particle or 100 particles, it doesn't assist in determining whether the particle came from the discharge of a firearm. And she gives that evidence. That's at 1986, line 14, through to 1988. And she says whether one particle is found or 100, the same conclusions can be drawn, i.e. person discharged a firearm, proximity, or contamination. But what she's making a different point in 1982, that the number and variety are relevant when assessing probability of population is GSR. And this comes back, I think, really to my Lord Lloyd Jones's question to me about variety yesterday. And I think I would answer it in this way. If all three types of one component particles are detected, so i.e. particles of lead, particles of antimony, particles of barium, it's possible that there are multiple sources by which those particles could have originated. It is also possible that all three of those one component particles could come from a single source. Now, that could be the discharge of a firearm, it could be a particular type of firework, it could be the deployment of an airbag. It is also possible that two of the types of one component particles came from one source and the other type of one component particle came from another. So overall, there are multiple possibilities where each of the types of one component particles could have come from. But when they're found in combination with two components or three components, the possibility that they came from the same source as the two or three component particles is greater in my submission.
Was there any evidence at the trial that was capable of supporting that?
The passage I just referred the board to at 1982, 9 to 22, is where Miss Merthyr, in my submission, is making this point about the potential relevance of number and variety of particles.
But isn't she here addressing the rather different question of the presence of traces which would be inconsistent with discharge as a source, which permits you to would require a scientist to discount those particular particles?
But, my Lord, it would be it's a sort of natural sort of step further to make the point that I've just made, which is when you have single components that are single components made up of the three necessary components of GSR, when they're found together with 2 and 3, it enhances the likelihood that they've all come from a single source. That's my submission. This
is the only passage you rely upon to support that submission, is it?
My Lord, it's the best passage that I found, and if I
But something about variety in one of the guides, isn't it? Number and variety.
It's the SWAG GSR guide. It's page 24. It's 3899, where it says that the probability that a population of particles is GSR increases significantly with number of particles, and then it talks about, and we looked at this yesterday at 3899, it then lists a number of factors.
But that's not evidence at trial.
No, the SWAG GSR guide was...
no, but that passage wasn't before the...
No.
Brought in evidence or...
No, my lord, no. The SWAG GSR guide was referred to in cross-examination of Mr White on the classification point and the and/or question.
And your expert specifically didn't agree with it because the number of particles, it has got no probative value.
Sorry, my lord.
The number of particles does not increase the possibility that it came from a gun.
The evidence that Ms Merthyr gave was very specific about three-component particles, and she said whether you have 1 or 100 three-component particles, it doesn't increase the possibility that the component particles came from the discharge of a gun. But when you're looking at the population of particles, the passage that I refer to and the submissions I made in reliance on the SWAG GSR guide is that number and variety do have relevance when interpreting a population of particles and the likelihood that that population of particles is GSR.
So you're saying there's a difference between saying it makes no difference whether we've got 10 antimony or 50 antimony, single component antimony. What might make a difference, and this is perhaps the controversial bit, what might make a difference is if you've not just got one component antimony, as apparently for some reason or other the airport seems to generate, but you've also got barium and lead.
My lord,
what you're saying?
Yes, it is what I'm saying. And so, for example, in a population of particles, if all the single component particles were, for example, lead, it might lead an expert to question whether the population of particles is GSR. But where you have single component particles that are comprised, that population, if I can call it that, of single component particles bear all the three elements, then that can be of assistance.
But that's really an argument directed to the fresh evidence rather than to the evidence that was at the trial.
Absolutely, my lord, because it simply wasn't explored because of this point about you just look at a population of particles.
Well, the answer to the question raised by Lord Hughes is put to Miss Merthyr at page 1983, line 15, isn't it? Garment with 10 one-component particles included lead, antimony, and barium.
Yes.
And she deals with that there over onto the next page.
Yes.
Yes. That's about it.
If I still really addressing the first ground, but obviously there's some overlap with ground two, the fresh evidence. The respondent's overarching submission on the fresh evidence is simply this, that no injustice can result from refusing to admit Ms Shaw's now 4 reports. And we say that because, properly analysed, they do not justify departing from the Court of Appeal's conclusions. Put another way, they don't cast doubt on the safety of the appellant's conviction. There is, though, a point that we take on timing. And more accurately, it is really why GSR evidence was not deployed by the appellant at trial or in the Court of Appeal. Essentially, whether Ms Shaw's evidence can properly be called fresh evidence. And as we said, paragraph 41 of our case, In the absence from any explanation from the appellant, it is to be inferred that a deliberate decision was taken by him not to rely on his own GSR expert and instead to rely on his co-defendant's expert, Mr. White. And in my submission, that does weigh against the appellant being granted permission now to rely on his own GSR expert on appeal to the board, effectively having a second bite of the cherry in my submission. But moreover, properly analysed, there is nothing in Ms. Shaw's evidence that is new in the sense that it was not practicable to adduce the evidence at trial or in the Court of Appeal. As we discussed yesterday, the Bermudan study, the most recent Bermudan study, could have been carried out at any stage. And we know that Ms. Shaw carried out surveys in 2014 and 2015, in other words, prior to the hearing in the Court of Appeal. And there's been no scientific advancement, there's been no breakthrough that is addressed by the fresh evidence. I mean, the thrust of the fresh evidence is essentially to make a point which was acknowledged by both experts at trial, which is that one component particles in isolation are of little, if any, significance. Proposed to deal, and I've touched on elements of the fresh evidence already, but I'll just take the four reports in order, if I may. Ms. Shaw's first report makes two main points. First, she says 1 and 2 component particles should not be reported in the absence of 3 component particles. And second, that 1 and 2 component particles found on the appellant could have been the result of contamination from either officers that arrested him or from the environment. As to that first point, for reasons I've already developed, we submit that that evidence does not assist in the present case, where the relevant population of particles consisted of 1 and 2 component particles as well as 3 component particles. That was the way that the evidence was presented and relied on by the prosecution and the defence. It's not been shown in my submission to be wrong. Even if it could be said, in light of Ms. Shaw's evidence, that it was wrong to consider 1 and 2 component particles alongside the 3 component particles found in Mr. Dill, the fact that the 1 component particles were found with 2 component particles is significant according to both ASTM guide and the SWAG GSR guide. Also, the board will remember the Australian study that that Ms. Shaw herself relies on, which referred to the significance of 2 component particles. That's 3407. So, in the circumstances, it cannot be sensibly suggested in my submission that when one looks at the ASTM guide, the SWAG GSR guides, that in the present case, the 1 and 2 component particles found in the appellant should not have been admitted in evidence. So in short, I say Ms. Shaw's evidence does not provide a basis for saying that the judge was wrong to have admitted that evidence, nor that the jury was misled in any way as to the inferences they could draw from it. The second point, namely the risk of contamination, you have already had my submissions on this. This was a central plank of the defence. Both Ms. Merthyr and Mr. White accepted that the particles could have come from numerous innocent sources, and the board already has the references to their evidence and the summing up. There was extensive cross-examination of the officers that arrested both Mr. Dill and the appellant in order to lay ground for the defence's principal contention that the particles found on both of them were a result of contamination from armed officers. And the board has a summary in the agreed statement of facts and issues, which included evidence from the officers that they took steps to reduce the risk of contamination, they wore gloves, etc. But the point here is that the jury had all of this evidence before them. They were in a position to determine this risk of contamination for themselves with proper directions from the judge. Ms. Shaw's second report, I think, essentially makes 3 main points. First is an extension of the point we've just been discussing, which is 1 and 2 component particles could have come from innocent environmental contamination, this time now bolstered by the Bermudan surveys. The second point is a point made regarding the evidence that Miss Helsel gave in the case of Trott. And the third, there are some specific complaints made about why some particles have been ruled in and some ruled out by Ms Merthyr. And again, briefly taking those 3 points in turn. The risk of contamination. The point Ms Shaw makes is, she says, the prevalence and commonality of such particles in public buildings and facilities used by members of the Bermudan general public. And she relies on a survey, I think she says a single survey in her second report, but as I'll show you in a moment, it looks as though she carried out 2 surveys, one in 2014 and one in 2015, and then a more recent survey that she carried out, which I'll call the Eurofins survey. And three points on this. The first is, and this is in my submission an important point given the evidence in this case, because in her first report, it's page 3407, Ms Shaw accepts that the presence of a 3-component particle does not rule out environmental sources, but it could be considered more likely that the 1- and 2-component particles came from a firearm when found in the presence of a 3-component particle. So in other words, the point Ms Merthyr makes at 3407 in her first report about the risks of contamination in my submission has significantly less force if, as in the present case, there were 3-component particles within the population of particles being analysed. The second point is the reliance on the surveys. And I don't know if the transcript from Levesque Roberts has reached your Lordship's laptops yet.
Yes.
I'm grateful.
It came in 2 parts.
Yes, I will only...
Because of its size.
You only need to open what is part 1.
Part 1.
It's all part of the same transcript, but actually,
I understand
I'm only going to refer you to There's simply a few points to draw your Lordship's attention to on this. So this is the... starting off with the examination chief of Ms Shaw in that case. And at, hopefully, if I give you the PDF numbers, I think page 9 should correlate to what is transcript page 1610.
Yeah.
And at lines 13 to 15, Ms Shaw's making the point there that she makes here, namely 1- and 2-component particles are found in the environment. At page 25, she's asked questions about surveys, and she says she's carried out 2 what she describes as very small surveys in Bermuda. Line 20.
Which page?
Page 25.
Thank you.
And we've got the dates. She gives us the date, 30th of April, 2014. And then you get the date for the second report later on in the transcript. I can tell you it's the 29th of January, 2015. And she then makes a point at page 34 that the results show that 1- and 2-component particles were prevalent in the general environment. So again, the point that she makes in her evidence in this appeal. Page 57, we're now into cross-examination, and she's cross-examined on her methodology.
Sorry, page?
So page 57, my lord.
57.
She's cross-examined on her methodology. And then at page 68, Ms Shaw accepts that she wasn't wearing any protective clothing when collecting the samples, and in particular that she wasn't wearing gloves. Although she makes the point repeatedly that she washed her hands before collecting the samples, and she makes the point at page 69, she says, I've removed any potential contamination to start with. So she's saying there, having washed her hands, that would remove any potential contamination. And obviously the point being made by the Crown's cross-examination there is that there's a clear risk of contamination, which is a point that Ms Shaw makes in this case about the police officers. If they weren't wearing gloves, there's a risk of contamination. So to use my learned friend's phrase, what's sauce for the goose is sauce for the gander. And the reason I draw Your Lordship's attention to that transcript, and I don't take any further passages on it, is really to get the two dates for the two surveys. The point that Ms Shaw is describing them as very small surveys, and the point that's made in cross-examination that there is a clear risk of contamination as a result of Ms Shaw not wearing gloves when she collects the samples. And the Eurofins survey, Ms Shaw in her second report effectively says the purpose of it is to build on the results of those two earlier surveys. That's what she says. And in my submission, it doesn't take matters further than the position at trial, namely that it was standard industry knowledge that 1 and 2 component particles are found in the environment, whether that's Bermuda or any other country. And to summarise the data that Ms Shaw relies on, the Eurofins data, there were 21 samples and 6 controls taken, the majority of which were analysed. Of the 21 samples, 6 contained no GSR-related particles at all. 1 was not analysed. 12 contained particles commonly associated with GSR, and 2 contained particles consistent with GSR. Overall, it can be concluded in my submission from the Eurofins results that particles commonly associated with GSR are common to the Bermudan environment. It cannot be said in my submission that particles consistent with GSR, two component particles, are prevalent. Of the 21 samples, only 2 samples with 2 component particles were found. And in addition, it is still possible that the particles found in those locations originated from the discharge of a firearm. So it doesn't take matters further than what the position was presented at trial in my submission. And the third point on this is the point already made, which is the jury had well in mind the risks of contamination from the environment. The next point, still on the second report, is the evidence that was given by Miss Helsel in the case of Trott at a trial in 2018 in Bermuda. And Ms Shaw makes the point that no significance is placed on 1 component particles as they are not of evidentiary value. That's the point that she makes in reliance on the transcript. Well, the short point in response is that's not what Miss Helsel said in her evidence. And the relevant part of her evidence is 3496. And she said at 3496, 1 components by themselves are not very probative, and the time it was taking to analyse those wasn't worth the evidentiary value that those results would have. So that perhaps goes some way to Lord Hughes's question about why the testing or the reporting of 1 component particles was phased out, the suspicion being it was time and cost intensive. But the point here is that she's talking about 1 component particles by themselves, i.e. in isolation. And then finally, on the second report, Ms Shaw questions Miss Murtha's ruling in and out of certain particles. And she's done this by reference to particles that are printed on data sheets. And in her second report, there were some photocopies of those data sheets. And the 2 short points on this. First, the images of the particles printed on those data sheets are clearly of inferior quality to the images reviewed by Miss Murtha on the scanning electron microscope. And thus her reasons for ruling particles in and out can't, in my submission, be adequately demonstrated by references to those images. And that is a point that Ms Shaw would have had to accept in cross-examination. And in fact, we see that she does accept that very same point in the Levesque-Roberts case. And the reference to that, I'm afraid this is in the second, if I'll just give Your Lordship the reference, but it's in the second PDF, and it's internal page 1687 of that transcript, which should be PDF page 7. The second point on this ruling in and out is, while gunshot residue particles can be smooth and round, as resulting from a high heat reaction, not all GSR particles are round in shape, and that's a point that's made by the SWAG GSR guide, page 3881. And that, in my submission, explains why particles referred to in, for example, figure 2 of Ms Shaw's second report, which is 3421, were reported despite being entirely spherical. Moving to the third report, and I can take this briefly, because this simply exhibits ASTM guide E3309 from 2021 and quotes the passage that we looked at yesterday. And the board already have my response to that, which is this is not a case where we're talking about one component particles in isolation. And so the paragraph relied on and quoted, namely paragraph 5.5.6, has no bearing on the present case. Moreover, as I submitted yesterday, this guide expressly says it is to be read in conjunction with the analysis guide and the SWAG GSR guide. And they make it very clear that one or two component particles, even found without three component particles, can have significance. And then finally, the most recent report, which is really a reply to the R.J. Lee supplemental report, just by reference to the paragraphs in what I'm calling Ms Shaw's fourth report. Paragraph 2, she effectively accuses Ms Leneve and Ms Helsel of taking the meaning of the SWAG GSR guide out of context in an attempt, she says, to elevate the evidential strength of the particles. And in my submission, that's both unfair and unfounded. The impugned section of Ms Leneve and Ms Helsel's report was essentially agreeing with the point that Ms Shaw had made as to why GSR experts do not use the expression unique when referring to three component particles, and explaining how there are other sources, potential sources of three component particles that can be distinguished from that of a firearms discharge. That's the point that they're responding to. And they make that point by reference to the SWAG GSR guide, page 3896, making the point that three component particles can be distinguished by morphology and composition, but this doesn't always eliminate some that are indistinguishable. Hence, you don't use the term unique. And they then make the point that there's nothing to indicate in the present case that the population particles they were examining was something other than a firearms discharge, i.e. based on morphology and composition. Now, that doesn't mean that the particles could not have come from a non-firearm source. All that is being said there is that there's nothing to indicate that they did. So they weren't using the SWAG GSR guide to elevate the status of what was found in the appellant. They were using it to discuss how other sources of three component particles can be distinguished from a firearms discharge. The next paragraph of Ms Shaw's fourth report, she says that Ms Leneve and Ms Helsel are wrong to attach weight to the fact that one component particles are found together with two component particles. Well, the board has my submissions. That is a position that is untenable in my submission based on the SWAG GSR guides and the ASTM guide. And Ms Shaw's wrong to say that. And if Ms Shaw is inviting the board, and my learned friend, relying on her evidence, is inviting the board to accept that, then Ms Shaw must engage with the wording of the ASTM guide and the SWAG GSR guide, which is clear on its face as to what it means. The fifth paragraph of her report, she says that Ms Leneve and Ms Helsel accept that two component particles can originate from firearms and non-firearms sources, but that the point they make about two component particles is not supported by the summary of the FBI symposium. And I say she's wrong. That's a misreading for the reasons I've given, and I've taken your lordship to that symposium, where you have only one person out of a sample of 102 random jurors was found with two component particles on their hand. And then finally, at paragraph 6, there's a point made about population particles, which I addressed yesterday when making my submissions on population. So for all those reasons, I submit no injustice would result from not admitting the report. It doesn't take matters further. It doesn't undermine the conclusions of the Court of Appeal, and it doesn't cast doubt on the safety of the appellant's conviction. Move then to ground 2.
Your position is reports should not be admitted. If they are, yours should be admitted. Is that right?
My Lord, yes. I'm entirely content that your Lordships look at all the reports, including my report, De Bene Essay. I say, given that the test is whether it's in the interest of justice to admit, for the submissions I've just made, I say it's not in the interest of justice. If the board were to admit, I still say doesn't cast doubt on the safety of the conviction when you look at the substance of the reports. Moving then to ground 2, obviously the complaint here is that the judge failed to give adequate directions. Now, as with certainly the majority, if not all, summings up, there are criticisms that can be made. But having read and reread the summing up in this case, my overarching submission remains the one that we make at paragraph 50 to 52 of our written case, namely the directions on the particle evidence and the GSR evidence in this case were a model of fairness and clarity in my submission. The headline points can be taken from those made by the Court of Appeal at paragraph 37, which is page 501. So headline point, first, the judge carefully described the limitations of the evidence. Second, on more than one occasion outlined the defence case, that nothing could be deduced from the particles found in the appellant, that they could just as easily have come from an innocent source as they could from a discharge of a firearm. And then thirdly, specifically leaving open the possibility that the particle evidence had no significance. If I turn, though, to the specific complaints made by the appellant, we address these in writing. It's paragraph 54 to 59 of our case. And I don't propose to repeat what we've set out, but propose to simply expand on some of the points and address some of the additional points that the learned friend has made in his reply. The first point that the appellant makes is that the judge's directions inflated the probative value of the particle evidence, and the appellant breaks that down into 5 separate points at paragraph 7.4 of his case. And take those 5 points in turn. First, it said that the judge wrongly directed the jury that the particle evidence was incriminating, even though no gunshot residue particles were found on him. And I say that doesn't withstand proper scrutiny when one reads the entirety of the summing up and the specific passages, in fact, cited by the appellant. The only reference that the judge made to incriminating particles was when referring to GSR particles found on Mr Dill's clothing. And he was plainly right to refer to GSR particles in the way that he did, given the expert evidence that they, in fact, came from the discharge of a firearm. And the relevant passage is 289, lines 18 to 21. The appellant next objects to the directions given by the judge in respect of the 3 component particles found on Mr Dill. Now, again, the board really already has my submissions on that. In short, I say it was entirely appropriate for the judge to direct the jury to look at the particles found on both defendants, given the prosecution case that they were sat one behind each other when Mr Dill was alleged to have shot Mr Robinson. And as I've already submitted, there was no suggestion by Mr White that it would be wrong to take account of the GSR particles when determining the significance of the particles found in the appellant. And on this point, in my submission, the judge's direction was entirely balanced. If the board look at the passage of the summing up that's criticised by the appellant that starts at page 79, and I took the board to this yesterday, starts at page 79, line 20, having referred to the expert evidence as to the potential significance of 1 and 2 component particles when present with GSR, the judge then goes on over the page at page 80, line 4, to say, or you may go the other way. You may think, well, look, he's the guy that has the 3 particles, this man doesn't have any, so maybe he committed the crime with somebody else. So in other words, the jury was specifically directed to the absence of GSR on the appellant and his possessions and told that that, in effect, could undermine the prosecution case. The third point is a point I have really already addressed in answer to Lord Hughes's question earlier, which is that the probative value of particles is not increased by number or variety. And the board have my submissions on that point. And as regards the judge's directions on that, I think the appellant cites pages 208 to 209, where the judge is outlining the prosecution case and refers to the multiplicity of particles found on the various areas of various items. Well, the complaint here, in my submission, mischaracterises the judge's directions. The reference to multiplicity of particles is a reference to the fact that there were different types and different quantities of particles found on the defendants and their possessions. The prosecution's point that the judge is reminding the jury of is that this is not a case where you have a single particle of gunshot residue being found on a single sample. This is a case where a variety of particles were found on a variety of different samples within a single population, and that was circumstantial evidence capable of implicating the appellant and Mr Dill. Now, the judge could have used different language, but all that was being conveyed is that several particles were found on these defendants and their possessions. And as well as outlining that that was the prosecution case, as I've already submitted, the judge repeatedly reminded the jury of the defence case that the particle evidence could have come from a variety of other sources. And you have the references at paragraph 56 of our case to the passages of the summing up.
Be absolutely clear about what your case is, about the number of particles. You accept that 3 component particles, the number's not relevant. Do you accept the same in relation to 1 and 2 component particles?
My Lord,
apart from the swag report, which wasn't referred to in evidence, that part of it.
My Lord, no, I say that the number and the variety of particles is potentially relevant when interpreting whether a population of particles is GSR.
Does that apply to 3 component particles?
My Lord, yes. The difference is you're interpreting a population of particles as opposed to go back to Miss Murphy's evidence, that whether you have 1 or 100 3-component particles, it's not going to tell you whether that particle is more likely or not to have come from the discharge.
Why doesn't the same apply to 1 and 2 component particles?
Because, my Lord, it's the likelihood. It goes back to the rationale for this, that the likelihood is that the population particles came from a single source. So it's the finding of 3 component particles with 2 component particles and 1 component particle, all with elements, necessary elements of GSR, that can be of.
That's the combination which increases the likelihood.
Yes.
But the numbers. Where's the evidence that the numbers of 1 and 2 component particles increases likelihood?
Well, other than what is said very clearly in the SWAG GSR guide.
But there was no expert evidence about it at trial?
Well, my Lord, no, it's not right to say there was no expert evidence, because the experts were asked about a number of hypothetical scenarios, and those hypothetical scenarios included putting to them different numbers of different varieties of particles. And the experts there answered those hypothetical scenarios and the conclusions that you could draw from them. For example, as my Lord Briggs pointed out, the passage of Miss Murphy's evidence, where she was taken to a hypothetical scenario of a number of 2-component particles being found on a shirt. But it is right to say that the issue, given the way that the evidence was presented, and without objection by the defence, and you're dealing with the population of particles, that was the focus, the fact that you had 3, 2 and 1 component particles all within a relevant population of particles, and that could have significance when determining whether they came from the discharge of a firearm, with it always being made very clear that you're talking about could rather than did. The next point that is made by the appellant is that the judge's directions risked, I think the way to put it is risked shifting the burden onto the appellant. But again, I say when one reads the summing up, that's simply not made out. In my submission, the overall effect of the judge's summing up on the particle evidence was to leave the jury in no doubt, and I've made this submission a number of times, that the possibility that particles found on the appellant and his possessions came from a gun as opposed to an entirely innocent source. Both were equally as remote in isolation. The final point is made that there's an unbalanced and unfair directions, and the appellant sets out 7 ways in his written case why they say the summing up was unbalanced. And we deal with this at paragraph 58, page 3544. And I'll just take these in turn and make some short oral submissions on them. We say first, it's wrong to say that the judge didn't properly direct the jury on the significance that no GSR was found on the appellant. That is precisely, we say, what the judge did at page 80, line 4, where the judge specifically tells the jury that the fact that no GSR was found in the appellant and his possessions was a point in the appellant's favour. Second, we say the judge reminded the jury on more than one occasion that contamination could explain the GSR and the particles found in the appellant. All of the points that the appellant makes at paragraph 7.15 of his written case were points in my submission that were made by the defence and considered by the jury at trial. The third...
Just going back for a moment to the first point.
Yes, my lord.
The way in which it was expressed by the judge wasn't a clear indication to the jury that there were no 3 component particles found on Mr. Hewey. It's all in the context of the possibility of an aggregation. If you look at the foot of the previous page, you might think, he says, just because 5 3-particle components are on one defendant and no 3 particles on the other, but they both have all these particles, the principle GSR experts speak about, that's where there are 3 component particles. The other evidence, maybe supporting evidence, may very well apply in that case in respect of both men. All right? And then he goes on to say, and this is the passage on which you rely, or you may go the other way. You may think, well, look, and then there's words missing, here's the guy that has the 3 particles, this man doesn't have any. So maybe he committed the crime with someone else and this fellow didn't have anything to do with it. And that's the passage on which you rely.
My lord, that's
a clear indication that there were no 3 particles.
Well, no, my lord, that's the passage on which I point to in response to a specific complaint that the judge never directed the jury that the absence of 3 component particles is a point effectively in the appellant's favour. And I say that latter part of that direction is clearly a direction that the jury can take into account the fact there's no 3 component particles found in the appellant as a point in his favour. But as to the earlier part of that direction, I say that's an entirely proper direction for the judge to give. And your lordship is right. That is the aggregation point. And the judge is referring to the principle that the experts talk about. And that's the principle that when you have 1 and 2 found with 3, that can be significant. So I say that is a good example of the judge directing the jury entirely properly on the expert evidence.
Thank you.
The third point that's taken, that there was no direction about the importance of control samples. Well, there's no basis in my submission saying that adding this point would have made any difference to the jury's verdict. The jury heard extensive cross-examination regarding the likelihood of contamination from armed officers, environmental sources. Being told about control samples would have added nothing of substance in my submission. Had it been a point worthy of mention at trial, counsel for Mr Dill or the appellant would have asked the judge to direct the jury as to it, as they were invited at the end of the summing up. The fourth point, the fact that 1 component particle was found on clothes the appellant was not said to have been wearing was a point that the jury were clearly aware of. And the fact that underscored the defence point that 1 component particles could be the result of innocent contamination was not a point that was lost on the jury. The point, and the fact that this was a point that potentially supported the defence, was clearly made by the judge by reference to the particles that were found on Mr Hutton's phone. And the board has those directions at 249, lines 9 to 23. And the judge describes the fact that you have 1 component particles found on Mr Hutton's phone as, quote, an important point for the defence. For the defendant.
249?
245, 9 to 23, my lord.
Thank you.
Fifth, the appellants say there was a risk that the jury would...
Does he actually say in relation to the phone that it could have come from the environment? Because he spends some time explaining how it could have come through Mr Dill or somebody else in the house touching it. Does he say, look, this could have come from the environment?
I don't think in that passage the judge specifically does, but I say that given the evidence and given the directions the judge gives about the risk of environmental contamination and the various sources, that would be a clear inference that the jury would draw if they were so minded. The fifth point is a point about speculation, and the appellant says, well, there's a real risk that the jury would just be left to improperly speculate. Well, the judge gave a detailed warning to the jury about not speculating. That's at page 26, line 2, through to 27, line 4. He repeated that at page 42 when specifically dealing with the circumstantial evidence. And he gave repeated reminders that the defence answer to the prosecution case is that it amounts to no more than speculation and they should ignore it. And you see those directions at 279, 352 and 355. The sixth point the appellant makes is about the amount of residue increasing with the number of shots fired. Well, that again was a point the jury would have had well in mind. And as already submitted, the jury were expressly told that the absence of GSR particles on the appellant was a point in his favour. And then the final seventh point, there's a complaint made that the judge didn't fairly sum up Mr. White's evidence. Well, that should, with respect, be given.
And Mr. Poole, I'm sorry you were interrupted.
My Lord,
I think we just have to hope it doesn't happen again.
My Lord, I was dealing with the seventh and final complaint that's made by the appellants on the directions, and this is that the judge, it said, didn't fairly sum up Mr. White's evidence, and I was saying, or inviting the board to give that submission fairly short shrift. I submit that the judge drew all material parts of Mr. White's evidence to the jury's attention. He gave detailed directions on his evidence, and those are at 319 to 327. As to Mr. White's evidence that he would have expected to have seen more gunshot residue if Mr. Dill had been in close proximity to a discharged firearm, that again was fairly summed up by the judge, and we see that at specifically 319 at line 13. And the point the judge is fairly, in my submission, making here is that Mr. White's answers were not qualified in cross-examination, in the sense that they didn't take account of conditions and circumstances in which the shots were said to have been fired, unlike Miss Murtha's evidence. And it was entirely appropriate for the judge to remind the jury of this, lest they might have been left with the wrong impression of the expert evidence. And just finally on ground two, before I move then on to the proviso, there were 2 points that were made by the appellant in all submissions yesterday on the judge's directions. The first relating to the fact that both defendants were said to have taken a bath, and the second about whether the judge left the jury with the impression that the defendants needed to have made contact with particles. Just want to address those 2 points. The bathing point. Miss Murtha's evidence was that several factors contribute to the loss of particles, and that includes washing. And she gave the example of washing your hands. And the references to that are in the SFI, paragraph 2.38, which is 3322, which summarises her evidence in that point. Mr. White agreed with that. He again gave the example of washing of hands as contributing to a loss of particles. And in the SFI at paragraph 3.12, his evidence is summarised, it's 3328. That is supported by the SWAG GSR guide, it's page 3952. And the SWAG GSR guide at that page says that washing hands will remove most, if not all, particles. And the board will recall a moment ago when we were looking at the transcript of Levesque-Roberts, it's a point that Ms. Shaw herself made when it was put to her in cross-examination, well, you didn't wear gloves. Her evidence was, yes, but I did wash my hands, and the reason I wash my hands is to remove the risk of contamination and remove particles. So the point made by the prosecution was an entirely fair point that had the defendants bathed earlier in the day, the likelihood is that they would have removed particles from their hands' bodies. And so any particles found on them would most likely to be deposited after they had taken a bath. That's the point the prosecution were making, and that's the point that the judge directed the jury quite properly.
Well, is it? Where does he say? So what the possibility that you've got to think about is whether any of these particles may have drifted onto them since they had a bath at breakfast time.
Well, the directions he gives, I mean, they're
3 o'clock in the morning when they're arrested, isn't it?
Absolutely, my lord. Yes. And the directions he gives are 240, pages 2 to 9, where he simply reminds the jury of the evidence that they bathed.
Yeah.
And then at 338, lines 19 to 23. And the jury would have had well in mind the evidence that was given, both by Miss Merthyr and Mr. White, as to washing of hands, i.e. bathing, removing particles. And so the jury would be able to put 2 and 2 together in my submission.
I think what's said against you is that at various points, and this is one, it looks a bit dismissive. What about the 2 points that Mr. Wood took us to specifically? 214. Would you like to just look at that briefly in case there's anything you need to say about it? I think that's the point at which he's inviting the jury to consider what in the world has made these two so unfortunate as to pick up.
I mean, it's very difficult, and I heard, as you heard, Millennium Friends sort of in square brackets, sort of dismissive in the margin. We can read what it says for ourselves. We weren't there. We don't know how the judge, the tone he used. All he's saying there in my submission is a summary of both experts' evidence, which is that it could have been the environment, it could have been a fireworks display, and batteries. But the key point, though, is if there was no 3 component particles within the population, then one might read that and say, well, that is being dismissive. But here he's directing the jury to consider a population of particles that contains 3 component particles. So it does make it less likely that the population, where you've got 3 component, 2 component, and 1 component, is GSR. And so that, in my submission, is an entirely proper direction for the judge to have given. And as he says at line 23, or is it more consistent with 2 men who went out on a shooting that night? I mean, he's putting effectively the defence case, although obviously our appellant didn't give evidence, didn't suggest anything positive, but Mr. Dill effectively was suggesting this is contamination from armed officers against the likelihood, or is it because they were involved in the shooting of Mr. Robinson?
But it doesn't end there, does it? Because the judge reminds the jury of a whole series of different items and the particles that were found there, which would have a cumulative effect in the minds of the jury. Then at page 217, he says, so here the prosecution has come again, 2 bikes, particles, grip, handle grip, passenger grip, 2 phones, particles, 2 hands, each man, 4 hands, particles. And then he says this, the prosecution is saying this, that these gentlemen are getting very unlucky that this kind of stuff is happening all the time. Isn't that dismissive?
Well, my lord, that is precisely the submission that would have been made in closing by the prosecution. And what the judge is doing in this section of the summing up, and this is why, obviously, one needs to read the summing up as a whole, he's reminding the jury of the prosecution's case. And then he goes on to remind the jury in detail of the defence case. And he reminds the jury on more than one occasion that the defence case is effectively, that it's entirely speculative. To agree with, if they were to agree with the prosecution about where these particles came from. And as I say, he says that on more than one occasion and goes through the potential innocent sources of contamination. So it's always difficult to, or one can always pick out passages that when taken in isolation may look as though they're dismissive. But I say when read as a whole, this is an entirely balanced and fair summing up in my submission.
Well, you're obviously right that you have to read it as a whole. Summing up is a tricky business. But it isn't enough, is it, simply to put in somewhere argument A and argument B, which is against it, if taken as a whole, it reads as if you are endorsing A and not B.
My Lord, I obviously accept that proposition, and I say when one reads this summing up, that is not the impression one gleans of the directions.
How about the word at 223, where he, line 8, so you might think the prosecution is entitled to say then, wow, so both jackets of both men have these kinds of particles too. And contrast that with your skeleton argument that is not conclusive or coming from anywhere or anything. The prosecution aren't saying wow, the prosecution are saying it's not conclusive.
My Lord, here though, the jackets, certainly, I mean, this goes, it's essentially the same point that the judge was making at 2483, where he's summarising the prosecution case. And was it the
prosecution's case that one component particles, and even in combination with two component particles, would lead to the proposition that that is something fantastic, by the word wow?
My Lord, I'm not being obtuse. I don't entirely follow your Lordship's point. I think all that the judge is saying here is in a summary of evidence as to what was found on various items of clothing. The clear impression one gets from the summing up is that the one component particles and two component particles are inconclusive when looked at in isolation. When looked at as a population of particles that include three component particles, then they derive relevance for the interpretation of that population of particles and whether it's likely to be gunshot residue or not. And as I say, that is when one reads the entirety of the summing up, including what is said about the defence case and including the repeated references to the defence case that it would be pure speculation to draw the inference that the prosecution is inviting the jury to draw. I say that this is a balanced and fair summing up. And the final point was just a point about contact, and I think it was an answer that my learned friend gave to my Lord Stevens' question. And it was suggested by my learned friend that the jury would have in some way been misled by the judge's reference to the defendants having to come into contact with the particles. And I think my Lord Stevens said, and there wasn't any expert or scientific evidence in support of that. And my learned friend said, no, that's right. But the direction the judge gave is the direction at 241, lines 17 to 22. And it's important to read that in light of the expert evidence, which is that particles could have been picked up, for example, Miss Merthyr said, by wind-blown dust. And Mr. White gave the same example of dust. So the reference to contact, when looking at the particles on Mr. Hewey, would have been understood by the jury as meaning simply coming into contact as part of potentially day-to-day activities. The judge wasn't, in my submission, suggesting anything more than that. It's not, for example, suggesting that you would have to have carried out some work involving sort of brake pads or been involved in a firework display and come into contact in a more deliberate sense. Contact here is just simply meaning everyday activities.
What about no credible evidence?
Sorry, my Lord.
See, the thing about the problem with this stuff being in the environment is that you won't know whether you've got it on you or not. I quite understand your point that most people probably haven't, but the trouble is that anybody might. So what's the purpose of saying to the jury there's no credible evidence of an alternative source? I paraphrase, but that's what it amounts to.
I think what the judge is saying there, based on the expert evidence, is more in relation to two and three component particles than one component particles. Because one component particles, I think both experts obviously agreed, and it was recognised in the industry that one component particles are commonly occurring in the environment. But it is less likely that you're going to have two component, and certainly much less likely three component. And so I think it can only really be talking about Mr Dill, who gave evidence. There was no alternative suggestion by Mr Dill other than contamination by armed officers, why he would have three component particles on him. Move then to the proviso. We deal with this at paragraph 60 to 63 of our case, page 356. Sorry, 3546. And as we say there, and as was held by the Court of Appeal, there was an overwhelmingly strong case against the appellant. So if, therefore, the board was to consider there had been a material irregularity, whether relating to the admission of the particle evidence or the way it was summed up by the judge, in my submission, no injustice can have resulted. This would be an entirely appropriate case for the board to apply the proviso. There were two main planks to the prosecution case. First, motive, and second, circumstantial evidence. If I can just take those in turn. Also, though, as regards the appellant, it's necessary to consider the strength of the case against his co-defendant, Mr Dill. Now, I say that because, as part of the jury's factual inquiry, they would have made relevant findings in respect of Mr Dill. And given his evidence that he was with the appellant at the time of the shooting, which was not challenged by the appellant, those findings are significant when assessing the strength of the case against the appellant in my submission. As regards motive...
Sorry, with the appellant at the time of the shooting, you mean at the time when the shooting happened?
Yes, my lord.
At that time of day?
Yes. Yes, my lord.
I mean, he certainly wasn't, yes, okay.
No, Dill's case, have I got it right, was that they were both in the Mid-Atlantic Boat Club?
My lord, that's right.
Yeah.
And that they spent the rest of the evening together. So, as regards evidence, there was evidence that there existed a feud between gangs. And the evidence of motive in this case went to identity, which was the core issue obviously in dispute. There was a general motive, namely gang membership and retaliation. There was also a specific motive, namely Mr Dill being publicly insulted by the deceased's mother. And the evidence regarding motive is probably most conveniently summarised in the SFI. It's paragraphs 2.6 to 2.9, which is page 3314 to 3315. General motive, Sergeant Rollin gave expert evidence in respect of Bermudan gangs and the culture of reprisal. And there's no challenge before this board to the admissibility of Sergeant Rollin's evidence. And my learned friend referred to a case of Myers, which was an additional authority that we handed up where my Lord Hughes delivered the board's judgment. It's a case from 2016, where it was held that Sergeant Rollin was sufficiently experienced to give expert evidence on Bermudan gangs and gang culture. His evidence was that both the appellant, Mr Dill, were members or soldiers in the 42nd gang. He stated that the 42nd gang were feuding with a rival gang called Parkside, and his evidence was that there was an expectation that as members of the 42nd gang, the defendants would be expected to conduct revenge attacks on those who were perceived to have humiliated or insulted a fellow gang member. And he gave evidence that there had been such attacks carried out on relatives of rival gang members in lieu of members themselves. And he stated that although Mr Robinson was not a gang member as far as he was aware, Mr Robinson's two cousins were members of the Parkside gang, so the rival gang to the 42nd gang. So as well as that general motive, Mr Dill had a specific motive, namely the insult he suffered at the hands of Mr Robinson's mother, where she accosted him and embarrassed him in front of fellow gang members. Now, it's submitted that the evidence and motive contributed to the proposition that it was the defendants who shot the deceased by supporting the other evidence that it was the defendants who were responsible. To put it another way, and as was put in the Myers case, it was evidence to rebut the argument, why on earth should these defendants, who have no proven connection or dispute with the deceased, have taken it into their hands to shoot him? The ballistic evidence, namely that the same gun was subsequently used in other gang-related shootings, was relevant as well, for the same reasons. The ballistic evidence of the connection between this gun used in the offence and other shootings, it could be inferred from that this was a gang gun, a gun that was accessible to members of the 42nd gang. So it was further important evidence to support the motive attributed by the Crown to the defendants. You also had Mr Dill's voice notes. And these were voice notes that were found on Mr Dill's mobile phone from 3 days before the murder. And my understanding of the voice note, these were notes that were sent, but the prosecution case, they didn't put in evidence who these messages, effectively voice messages, were sent to, but they did leave Mr Dill's phone. And what he said there was that, to paraphrase, he was the only member of the 42nd gang who had the heart to kill someone.
Can you just give us a page for where we've got the text, if we have some?
No, it's summarised at paragraph 7 of the Court of Appeal's judgment, which is page 490. We don't... Well, I'll be corrected if I'm wrong, but I don't think we have the text.
Okay.
Mr Dill accepted, though, in evidence that he left those notes. That's at 2748. And his cross-examination about the notes is 2748 to 2761. And so you derive from that cross-examination, because obviously the text or what is said is put to him. So you derive some of that from that cross-examination.
Thank you.
Now, the appellant takes the point that these voice notes are not probative evidence against the appellant, and also, they say, are not relevant to this appeal. Well, I say, certainly as to that second point, they're wrong. They're clearly relevant to this appeal because they're relevant to the consideration of the jury's factual inquiry, for reasons I made a moment ago. The jury convicted Mr Dill, and in so doing was obviously certain that he shot the deceased. These voice notes would have informed that decision. And Mr Dill's guilt is relevant when considering the appellant, given the unchallenged evidence that they were together. Now, evidence of motive was therefore, in my submission, an important strand in the rope of evidence that there had occurred a trigger event which would have created a grievance in the gang of which the defendants were members. Now, the appellant makes the point in his written case that, well, yes, but that applies to any member of the 42nd gang. Well, no doubt that's correct, but a shared motive can be just as relevant as a motive harboured uniquely by an individual. And the shared motive is still relevant to show that Mr Dill and the appellant had a reason to do what was alleged by the Crown. In addition to motive, there was other evidence that supported the inference that it was the defendants who shot Mr Robinson in a joint enterprise. There were the gunshot residue particles found on Mr Dill, which I've already explained why I say they're relevant to the case against the appellant. There was evidence of telephone contact at around the time of the murder between Mr Dill and Mr Paris, and Sergeant Rollins' evidence was that Mr Paris was the leader of the 42nd gang, and there was also the attempt made by the appellant to call Mr Paris. And you have the schedule of the calls at 3303 to 3310. And there was a point that was noted by the Court of Appeal on this, that there was attempted contact by Mr Paris after the event to both Mr Dill and Mr Hewey. You have Mr Busby, the eyewitness. He described the bike as a black Honda Scoopy, matched the bike owned by the appellant, which was then linked by DNA and prints to the appellant. Now, as to the point that's made by the appellant, Mr Busby's general description didn't match the relative builds of the defendants. Well, Mr Busby explains, or certainly gives an explanation for that in his statement. And he says in his statement, it's 720, line 24 to 721, line 36. It was difficult to be certain of the relevant builds of the two men on the bike because they were seated on a motorbike and the man on the front may have been crunched or leaning over. As to the point made about Mr Dill's jacket not matching Mr Busby's description, well, that was a point made by the defence at trial. It would have been considered by the jury alongside the rest of the evidence. And the fact of the matter is that Mr Busby described dark clothing, and Mr Dill's jacket was black but with some red in it, and the other jacket was grey with some red in it. There was the appellant's call to his mother shortly after the shooting. Now, the appellants say, well, that's irrelevant because news of the shooting had, by the time of that call, spread around Bermuda. Well, that doesn't make the evidence irrelevant. Moreover, the appellant chose not to give evidence and so offered no alternative explanation for the call or how he might have learnt about the shooting. And then you have the appellant's arrival with Mr Dill back at Palmetto Road, coming from the direction of the next door house where the bikes had been placed out of view from the street. Black helmets matching Mr Busby's description. Now, as to this, the appellant say...
Is it correct that it was accepted by the prosecution at the trial that his bike, Mr Hewey's bike, was usually stored next door?
That was the evidence that was given by the mother, and the prosecution case was nevertheless that these were not just stored next door; they were stored round the back of the house, and they would say concealed from the road. And there were photographs put before the jury to show precisely where the bikes were, and the fact that they were not, for example, by the side of the house or in front of the house; they were round the corner so that they couldn't be seen from the road. And that was the prosecution case remained that they were effectively hidden from view. But it's right that the mother gave evidence that he would normally store the bike at the next door's house.
I understand the appellant to go further than that and to say that the prosecution accepted that they were bikes were normally stored there. Mr Hewey's bike was normally stored. That's what said. Well, perhaps Mr Wood will be able to help us in due course.
Well, yes. I mean, I can. If that's the case, I will ascertain whether that's right or not.
Thank you.
Some evidence that the rival gang knew his motorbike.
Sorry, my lord.
I think there was some evidence that the rival gang knew his motorbike.
My lord, yes, that's right.
Which might have been a reason for storing it around the back, irrespective of whether he killed somebody.
Well, my lord, again, I mean, yes, that could have been, no doubt, a point made by the defence. I'm just looking at the SFI to see if that answers my Lloyd Jones's.
The judge is summing up at page 176.
Sorry, my lord.
The judge is summing up at page 176 says the enemy knows his bike. Is one of the references.
And I may have misunderstood the point which is made by the appellant. It's the appellant's reply, paragraph 27. It was the prosecution evidence that it was usual for the appellant to park the bike in his neighbour's rear yard.
Well, because mother was called by the Crown.
Mother was called by the Crown, exactly.
Yes, that's right. So, my lord, taking the point I've made on motive and the points of the circumstantial evidence, I submit that the Court of Appeal was bound to reach the conclusion that it reached, namely that this was a strong case against both defendants, and that's the point that they make at paragraph 49 of their judgment, page 507. I do invite the Board to have regard to what the Court of Appeal say at paragraph 51, which is, again, same page, 507, as regards the case against the appellant. They note, calling no evidence, didn't challenge Mr Dill's evidence that the two of them were together. This meant, they correctly say in my submission, that the gunshot residue particles and the phone calls were relevant to the case against the appellant. And I say that their assessment of the evidence and the strength against the appellant is plainly correct and one that should be endorsed by this Board. If the Board is against me and is against me on proviso as well and is minded to allow the appeal, then we do submit that this is a case in which the Board ought to order a retrial. Whilst it is acknowledged that the appellant has been in prison for a number of years, there is a considerable public interest in ensuring that grave crimes such as the present should not go unpunished. In my submission, there are three main factors that point towards a retrial rather than acquittal. First, the nature of the killing. This was a deliberate shooting by people who had clearly sought out the victim in order to kill him. Second, the importance of the case in Bermuda, given the fact that this is a gang-related killing and the problems that are acknowledged in the case of Myers, the problems Bermuda has with criminal gangs. And thirdly, the strength of the case against the appellant. And a retrial, of course, would include Mr Dill's conviction for shooting the deceased and the evidence that... the logistics of a retrial we don't need to go into. But for those reasons, I say that this is a case where if the board is against my primary submission that the appeal should be dismissed, then this is a case to order a retrial. Just very briefly, on the appellant's new ground of appeal, this is the jury selection point, and it's really just to draw your lordship's attention to some factual details. The instructions from when this point was first taken, obviously we sought instructions from the DPP's office and from trial counsel for the Crown, and based on the prosecutor's notes of the jury selection in this case, and we now have the transcript as well of the jury selection, that the facts in my submission are Mr Dill challenged 2 jurors without cause, the appellant challenged 3 jurors without cause, the prosecution stood by 3 jurors, and then the court excused 16 potential jurors for various reasons provided by those jurors. So we say the factual basis on which this ground is pursued, which is set out in the appellant's printed case, is effectively that 13 jurors were stood down by the Crown without cause. We say that is wrong.
When you say the court excused them, did they do that at the invitation of the Crown?
No, my lord. It was, one can see from the transcript that effectively the jurors give various reasons themselves as to say, for example, I know the defendants. And so we say there is no basis to contend that his trial was unfair on the basis of apparent bias and jury selection, based on the trial transcript, the prosecutor's note, and those instructions from the DPP. Lord, if I just turn my back briefly. My lords, unless I can be of any further assistance, they're my submissions.
No, thank you very much, Mr Poole. Yes, Mr Wood.
Hello, can I start by just dealing with one or two of the brief points that have only recently come up in argument. And my Lord Justice Lloyd-Jones raised a moment ago about the bike being at the back of the house. The photographs which aren't before you clearly show that the home is, if I can put it, hard on the road, no pavement between the house and the road at all. There's space round the side for the parking of a bike and at the rear. And so, my lord, to park the bike outside the front of the house would be something that one could not effectively do because it's so hard on the road. And so I just thought your lordship should have that. My lord, can I then turn to the transcript again, that's been placed before your lordships concerning Angela Shaw and her evidence in the case of Levesque Roberts. She, first of all, deals with the point about the absence of gloves by making it plain that there was controlled samples taken from her during the course of the transcript. But, my lord, that transcript having been put in, that was her evidence before our trial judge, Judge Greaves, and his subsequent treatment of her in the summing up led to the appeal which you have, in which, just to briefly summarize the position in paragraph 36, and we place this judgment before your lordship so you can see. The Court of Appeal, I would submit, roundly criticised the trial judge for his comments upon her evidence. They did so at paragraph 36. They cited his comments at paragraph 37, describing them as a most unfortunate passage because it contains unjustified criticism of Miss Shaw and seems to have been based on misunderstandings of her evidence. There was much common ground between the experts. And then conclude, I cannot accept that Miss Shaw exceeded her role, which was the allegation that was being made against her by this trial judge in the context of this evidence when she had laid before the court the very small survey which she had done on that occasion. And I make it absolutely clear that was a case where Levesque Roberts had a full 3-component GSR on him, and that brief survey was conducted to see the prevalence of full 3-component GSR simply for the purpose of that case, and did not in any way address the evidence concerning the fresh issues that you have in the now more wide survey that contained in her second report. So I put those matters in context, and your lordships have that transcript. My lord, by way of introduction, our core submission in reply is to express simply a concern that if the overall position adopted by the state of Bermuda and on their behalf by my learned friend, and if the course that was adopted in this trial in terms of what I do describe as an unrestrained admission of 1 and 2-component particles on diverse exhibits is accepted, adopted, and approved by this court, then your lordships will effectively be opening the door to a reporting practice in relation to gunshot residue, which could place the common law jurisdictions at odds with the worldwide scientific community as to what can actually be proved by the admission of these 1-component and 2-component particles, and the use which can properly be made of them. The practice adopted by the prosecutors and the courts in Bermuda, and endorsed by the Court of Appeal, we submit was so obviously wrong that those who had adopted it in recognition, according to Miss Halsell's evidence, only shortly after this, themselves stopped the very reporting of the 1-component particles, even in their reports. They were to cease altogether to report upon those 1-component particles. Such was their lack, we say, of capacity to prove something significant. Through their further report placed before your lordships last week, they have sought to justify the course that had been adopted by advancing a hypothesis which in fact had to be proved, and this is the essence of our submission, had to be proved before it could ever be possible to use these particles as a tool to assist interpretation. All the guidance is clear, we submit, apart from the passage which my learned friend has very much relied upon at page 3899 in the SWGGSR, never referred to or relied upon by the witnesses during the course of this trial, and that because we submit it does not fit within the guidance now before the courts as illustrated and deployed by the experts in the expert community, heavily relied upon that passage at 3389 into 390, yet the experts themselves, none of them in the trial, actually seek to rely upon it. The guidance we submit is clear, and I will come back to it in detail from the various reports which you have from the ASTM guidance in 2017, 2020, and 2021. Our submission on ground one is that, indeed, the single and two component particles should never be admitted, and I say this as a matter of course or routine, as happened here. And I say that to emphasize our submission, that here it is said that the presence of 5 three-component particles on someone else, and I will come to the diversity by reference to the schedule in due course, on Mr Dill, can now be said to form the justification for the admission against my client of all of this material concerning 1 and 2 component particles. None of it, we say, is justified by the circumstances of this case. Our submission is that any admission of 1 and 2 component particles can only be justified to explain the 3 component particles as happened in the case of Dwayne George. The passages to which my learned friend has referred at paragraphs 46 and 47 effectively make it clear what was happening there was it was 1 coat, it contained 2 3-component GSRs and 2 2-component GSRs, properly admitted to explain the context of the 3-component GSRs. My Lord, I turn to what is really the key issue in this case. For the Crown seek, relying upon the American SWGGSR codes and guidance, to justify the admission of all particles on the basis that they become a population. We submit that that was not even something that was advanced by the experts called at the trial. They expressly did not. It was, we say, a completely proper interpretation of what the trial judge was seeking to say to the jury that they could do, but it wasn't ever the approach of the experts. My Lord, Miss Murtha deals with that question of population at a passage to which your Lordship's attention has previously been drawn, 1982, line 6. She was asked at page 1982, you said something earlier, I think you said that you also looked at the population. Could you explain what you mean by that? Yes, along with looking at particles individually, to see if one particular particle has a high amount of iron or an amount of magnesium present. I'm also going to look at the total population of particles present on a sample. And of course, here she was speaking in the context, of looking to eliminate particles. So, for example, if I have a sample that has a few 1 or 2 component particles, but it also has a lot of particles that are just lead or, that are just iron, that would indicate to me that I have a population that wouldn't have come from the discharge of a firearm. They are flagged in the instrument. My Lord, she deals further with it, making it plain that population to her is the population in the sample. She never analysed all the samples together. And she couldn't. She couldn't analyse all the samples together because she did not, on her analysis, have any idea of the location of where these samples came from. She's never provided with that kind of information. Mr. Dill's expert said similar things at the electronic bundle, page 29227 to 2928 and into 2929, and I invite your Lordship's attention to it. They were saying, both of them, that population is population upon the sample. Neither expert was ever asked anything like whether particles on one suspect can be supportive of the particles upon another, or supportive of having come from a gun, or whether particles on one garment can support the assertion that particles on another garment came from a gun as well. They certainly did not specifically say that the gunshot residue particles on Mr. Dill were supportive of the particles on Mr. Hewey coming from a gun. My Lord, in any examination of what amounts to a population, one would have to be satisfied before one could take any population. Positing the example that Miss Merthyr took in her latest report of two men on a bicycle, we say simply that what the respondent is doing here is putting the cart before the horse. Until one can prove that all these items are together, one could never even begin to consider them as a population. We, my lords, dealt with this in our note in response to her expert evidence at paragraph 7 on page 6 of that note, where we made 6 points concerning effectively the one component particles being supportive of two component particles. And in paragraph 8, we made points concerning the hypothesis advanced by her concerning the two people on a bike. These items, my Lord, were not found together. They were found on distinct occasions. My Lord, can I invite your Lordship's attention to the schedule that we've now given your Lordships, because it's actually quite interesting to see how this actually all stacks up and what's happened here, and how it is obviously, we say, wrong to take them as particles, or as group them all together. My Lord, the schedule extends to some 8 pages, and as you have been told, now contains not only the particulate in relation to my client, Mr. Hewey, but also the particulate in relation to Mr. Dill. The first point I make, my lords, is that none of the seizures happened in any way contemporaneously to the shooting itself. It's certainly not a ground zero, as Miss Shaw put it. The schedule illustrates, we say, that these items are not a population. Of course, a number are seized from the appellant's home address. A number, though, and primarily all of those, or principally a very large number of those relating to the defendant Dill, are all seized at the police station, and one can see that from page 5 through to page 6, the very large number of items seized from him at the police station.
So that's what he's wearing, is it?
That's what he's wearing and what's taken on, and of course, that's why there was a particular issue so far as contamination was concerned, so far as he was concerned, an issue that wasn't actually dealt with within the summing up, and we've made that.
But leaving on that aside, he went straight from Mr Hewey's house to the police station.
He does, and there's absolutely...
And he didn't change his clothes between leaving Mr Hewey's house and getting to the police station.
Well, whether he changed his clothes beforehand or not...
No, but you're seeking to distinguish between items seized at Mr Hewey's address and items seized at the police station from Mr Dill.
I do.
But if Mr Dill simply came under arrest from Mr Hewey's house to the police station, does it? I'm not sure I understand your point that that's really separate or different.
Well, my lord, it makes...
Apart from the police contamination point, which is a separate point.
Well, it is, my lord, but if one's going to group it as a population, then one has to ask what has been proved about whether these articles were together. The dilemma is it the cart before the horse or the horse before the cart? Because in my submission, putting this all together and saying they are a population makes it... They can only be a population if the prosecution had proved that they were on the bike.
Well, did Mr Dill gave evidence, and did he say that he changed his clothes after coming back from...
I'm sorry, I don't know the answer to that, my lord.
Well, the answer is no, presumably.
He didn't.
So he was in the same clothes that he was wearing whenever he entered the house?
Yes. So he said. And Hewey wasn't, yes, is what I'm told. But, my lord, can I then come to more illustrations of the difficulty?
How do we know that Hewey wasn't? Mr Hewey didn't give evidence.
Yes, my lord. The clothes are seized from his bedroom. He's not wearing them at the particular time. But, my lord, if you go through it, let me just posit this example. Black jeans, of course, were relevant, potentially relevant. But so far as Mr Hewey was concerned, the item WB3 was a pair of black jeans. The item WB11 at page 3 of the schedule was a pair of black jeans. My lord, 2 pairs of black jeans, and indeed the item WB1 was items 10, 11 and 12 in the schedule, was a pair of black jeans. All put in, say the prosecution, to the same population, indicates in our submission the ludicrousness of the position. What was their case so far as those were concerned? What was their case? They were seized at the house. 3 pairs of trousers. It was never part of the prosecution case that Mr Hewey was in any way wearing 3 pairs of trousers. And yet actually, if you look at what was discovered upon them, 2 of which could not have been part of the population, there's something of a consistency in relation to contamination between the black royal blue jeans, the black jeans, and the black Texas jeans, my lords. And our submission is that it indicates the inappropriateness of what has happened. I then turn, my lord, to the red and grey jacket. That is the one which principally has the two component items upon it. You will notice that actually the evidence so far as the recovery of that jacket is concerned is completely separate and distinct. Because of its description, it was thought to be said by the prosecution and by the learned trial judge that it had somehow been worn during the course of the shooting, and that emphasis was made because of the two component particles. It's at items 31 to 34 on the schedule, my lord. The circumstances of the recovery of that item, some 3 days later, on the 2nd of April 2011, from Mr Hewey's bedroom, were that his mother had telephoned the police to say that She thought it was there, the jacket that he was wearing that evening. She thought it was there, and it was then at that stage seized. Not part of a population in any sense, we would say, to my lord. So, my lord, I go to... sorry, just trying to... Yes, I go to our note, my lord, at paragraph 7, our note in response to the report. The expert evidence, our appellant's response to the expert evidence. Oh, I've taken your lordships to it. I do apologise. Paragraph 7 and 8, where it deals with population. My lords, what I would seek to do is simply to take your lordships back in this reply to the clear guidance at E3309 21 at page 3438. This, we say, is absolutely central to good practice. I draw your lordship's attention again to paragraph 553, which makes it plain, despite what was being said, that the number of confirmed particles cannot be used to determine which of these scenarios is more likely. This is in connection with consistent particles and the 4 propositions that are there set out. We now know, clearly and based upon evidence, that those particles are prevalent in the background. My lord, I draw your lordship's attention clearly to paragraph 556, and I want to make a caveat about the exception. No interpretation can be drawn from the identifications of particles that are commonly associated with PGSR. My lord, many of the, indeed all but 2 of the exhibits placed in evidence before the jury have only single particulate. The prosecution's case is that they can draw attention to that and that the jury could somehow be entitled to draw probative value from that by reason of the fact that some others had 2. There were a total of 3 2-component particles, consistent particles in this appellant's case. In our submission, this includes lead, barium, and antimony particles found in isolation in the absence of characteristic and consistent PGSR particles. And our submission is clear that those particles cannot, of themselves alone, have any probative value at all and should not be led in evidence, my lord. As to the exception, do not report the confirmation of such particles as potentially having originated from the discharge of a firearm, except possibly, and that passage, except possibly, in the case of the following.
Well, nobody's relying on 5561, are they?
No.
It's the second sentence which is what you've got to focus on.
My lord, my submission about that is that the reality is that all of these exhibits that had only one component upon them, the vast majority, could not in any way be admissible and probative. This is not saying, this is absolutely not saying, if you have some exhibit with 2 components on it, the door is open to all other exhibits with simply one component upon it. My Lord, one only has to, and to suggest that they can somehow constitute a population when their history is unknown, their background is unknown, and it is wholly, wholly wrong. And so those comments...
But there must be some limit to it, mustn't there, Mr. Wood? It's got to depend on the facts. I mean, supposing you've got, for example, a motorcycle and the leather jacket that its driver was wearing.
My Lord,
they're two different articles, but there may be quite good evidence that they're connected very closely.
My Lord, that is why I make the submission that, as a matter of routine, these particles are not reported, they should not be admitted, but there may be particular circumstances where they should be admitted. But, my Lord, what has happened here is that the trial judge took this absolutely en masse, said, no, they're all in, and I have to say yes. So far as I've been able to see, and I've not seen the transcript of the submissions, there was no separate and distinct submission that we are aware of. But certainly, so far as what the trial judge did was...
Now, that's quite different. We do need to get clear in our minds what your basic submission is, Mr. Wood. You started yesterday by saying that your submission was that both two-component and one-component particles were inadmissible, full stop.
Yes, my Lord.
It doesn't sound as if you're now saying that at all.
No, my Lord, I think I've always made it clear that our submission is they are not probative, there is no probity in them, and therefore, save in exceptional circumstances where their probity is established, they can be admitted. So I'm not saying in all circumstances it has to go. Right. I'm saying in the circumstances of this case, they should have been excluded. They have no probative value.
Well, that's quite different.
Or, and we make that submission, this submission as well, their probative value is so minimal that it's outweighed by their grossly prejudicial effect.
I think you're accepting that if you have two items of clothing which are definitely were worn, and you can establish that they were worn by an individual, then you can look at the particles on both items of clothing.
I do accept that. The difficulty that we have here, my Lord...
Well, if I could, before getting an answer to that, was that point put to the trial judge? Look, you cannot prove that these two items were actually worn at the same time, at the time, by Mr. Hewey, and therefore you should not, on that basis, admit this evidence in relation.
No, my Lord, the cross-examination always was that he had nothing to do with it. But I do not know whether that point was put. It is not reflected in his judgment in any way. And I do not have, and I do not know what the arguments were that were advanced, but I can say, and I do agree, that if that point was made, it was not answered by the trial judge or touched upon by the trial judge.
If it's going to be dealt with at the stage of admissibility, you say it can't even be admitted, one item particles, unless it has been established that there is some special basis for doing so.
Yes.
But what if the prosecution says, well, we seek to establish that there is a sufficient basis on the footing of our evidence when the jury looks at it as a whole? Are you suggesting there has to be a sort of trial within a trial to see whether that can be proved at half-time? If so, before who and adjudged by who?
Oh, by the judge.
But that's not how trials work.
No.
Any more than that they work by the forensic scientist alone deciding the case, which is where we're going if you're not very careful.
My Lord, can I make it clear, maybe I misunderstood your Lordship's question. At the stage when this evidence was to be placed before the jury and the start of the case, a submission was made concerning it. It's at that stage that if there is any particular justification for the admission of those particular particles, based upon the expert evidence, that the trial judge has to rule upon it. That is my submission. Absent such a particular explanation as to why it's necessary, if one looks at the code of practice as set out here, they would not be admissible. They are not prima facie probative. And that is our submission so far as that is concerned.
Well, you can have a trial within a trial in relation to the admissibility of a statement and whether that has been extracted out of it. But have you ever come across a trial within a trial in relation to any other aspect?
But, my Lord, it's exactly what happened here. It's exactly what happened here.
Well, but what I mean by trial within a trial, that is evidence being called, witnesses being cross-examined, and so on.
I'm not suggesting that that would be necessary.
I'm asking you for illustrations.
Then, I'm being corrected in saying that that has become the practice in Bermuda to try and do that.
Sorry, what has?
For the experts to give evidence on a trial within a trial. I'm told that has happened.
Well, the experts might. I can see that the judge might sometimes want to hear both experts on the question of admissibility, but it doesn't answer the fundamental question which Lord Briggs has put to you, which is what do you do if you're right that there has to be established some connection between Exhibit A and Exhibit X before you can consider them together, or before you can consider the particles on X. What do you do if the prosecution say, well, we think we are going to establish a connection? We're going to call several people who say they saw them being worn by the same chap. And the defence say, well, we don't agree with any of that. It's hotly in dispute. What are you supposed to do about that?
Yeah, my Lord, in those circumstances, it would be admitted.
It would, wouldn't it?
It would, yes.
Have to be.
No.
But play that out in this case. The prosecution was seeking to treat as a single population items found on Mr Dill and on Mr Hewey, because the key to their case, as the judge frequently reminded the jury, was they were in it together, they were all on the same motorbike. Dill was the shooter and Hewey was the driver, and we seek to prove that with all the evidence we want to deploy in the case. Now, if that's their case and they say they're going to seek to prove that with evidence, how can the evidence be how can the X1, the single element particles, be left out?
No, my Lord, in my submission, they have to be, unless it can be proved.
Well,
unless it can be proved that they are together.
If you're right about that.
You cannot deploy, or there's another way to look at this, my Lord, which is to say, if it happens that that's the issue, then the trial judge should be directing the jury that unless they're satisfied, that these items were all together, they have to ignore it.
Well, that's an entirely different submission. You might or might not be right, but it's completely different from the admissibility submission, Mr. Wood.
Well,
and you started this appeal by telling us that you wanted us to lay down rules for the Caribbean generally about the admissibility of this kind of evidence. And I'm bound to say, I speak only for myself, at the moment I simply cannot see how we can even begin to do that.
Well, my Lord, what's happened in Bermuda, we say, has in this case given rise to a grave miscarriage of justice.
Well, that's a different question.
And this is a practice that has emerged in Bermuda particularly, not adopted in other Caribbean countries, of routinely placing before juries all of the one component particles. It's a practice that has now ceased, and ceased because of the steps taken by R.J. Lee to stop reporting on these particles.
Okay.
But at that time, before this trial judge, that was what was routinely happening, and it gave rise to the concern that your lordships have found expressed in the various reports. My Lord, I'm going to move simply to...
A defendant could frustrate the whole thing by not answering any questions at interview and not giving any information at all about what clothing he was wearing.
Wow.
And potentially justice wouldn't be done.
Well, my Lord,
Well, that's inherent in the rules about interviews, I'm afraid.
Well, I think the point is answered, my Lord. My Lord, can I turn to the issue of the proviso? Should you be with me on these arguments? We dealt with the issue of proviso in our skeleton argument in response to the respondent's case. We did so at page 3861 to 3862. My Lord, we set out the points. They're echoing some of the points that we've made at the outset of this case concerning the strength of the case. Our submission is that there was nothing that actually put this defendant on that, this appellant on that motorbike, other than the interpretation of the GSR material. And if you're with us on this appeal, there can, we say, be no question, looking at the balance of the evidence, there was not a case to answer against him. A submission of no case would have been successful. And in those circumstances, we say to your lordships that the proviso should not be applied. If you don't apply the proviso, our submissions on retrial are contained in our case at paragraph 10, page 3371 to 3372.
You can take it that we've read that.
And our submission is that no retrial should be ordered. And my Lord, I'm 1 minute over my time.
That's quite all right.
Well done.
Thank you very much. Well, we're most grateful to both counsel and their supporting teams for all the submissions we've heard, both orally and in writing, and the supporting written materials such as the schedules, which have been very quickly prepared and delivered. We will take time to consider what advice we will humbly tender to Her Majesty.